Good morning, everybody. I appreciate you having me today. My name is Tim Smit. I am the Senior Global Cyber and Privacy Risk Consultant for Lockton Companies. And we're going to talk about privacy around the world and with what my role is and how we see it today, and hopefully provide you some valuable information on what to prepare for not for just today with what the regulatory landscape looks like, but what it's going to look like tomorrow. So I'm actually going to go past that screen, which is a precursor to this screen, if you will. We're going to talk about HIPAA, of course. We're going to talk about GDPR, California Consumer Privacy Act, the California Confidentiality of Medical Information Act, Nevada's Senate Bill 220, which is more of an online privacy law, and then some other recommendations within the GDPR piece and how they correlate with HIPAA and where HIPAA is or potentially going to go. While we do that, there's going to be two scenarios that I'm going to walk through when we go through this. And it's going to talk about access controls and hiring processes in those capacities. It's going to bleed over to patients' information as well and how those individuals handle that information. But as we go through that, think about you as your own individual going to a medical facility, either yourselves, your parents, your children, and what information actually is being captured as you walk in the door, how that information is being protected, and so forth. And it doesn't matter where you are in the world. It's the same concept accordingly. So today, as you can see in this screen, the U.S. privacy law map, there are a number of privacy initiatives across the U.S. And within that, we've got a number of them that have been turned down. Washington was one that did not quite make it to the finish line. However, there are a number of reversions, re-editations that are going to be proposed next year, where I believe this screen will actually turn into more reds, more liable policies across the board. We do have biometrics laws in Illinois. Florida has one as well, and other states are also taking that into consideration. So as you go forward and thinking about how you work internally for your organizations and or you're capturing biometric information for access and or for other reasons, the privacy around that particular area is going to become more stringent, and taking into consideration, again, how and where your organization's footprint will touch will also drive how you're going to protect that information and show compliance with that. This screen shows just a depiction of the comprehensive laws and what the overlaps are with what you are needed to provide. Most of the states have a data protection law as well, and where that complies with healthcare, depending on the states themselves. Of course, HIPAA is going to preempt most of those unless the statutory laws are much more stringent. The error is always going to fall on with what provides the best protection for the individuals. Again, that's across the globe. It's not just the U.S. Whatever acts or laws or regulatory requirements there are, if it provides you, the individual, with better, stronger controls, that will take precedence. Now, changes in the U.S. So back in December of 2018, the OCR sent out a request for information on HIPAA. And what they are driving towards is access, and we'll talk about that here shortly, the privacy of information, who you're sharing that information with and how you're sharing that with, and then similar to the consumer or the California Consumer Privacy Act, which we'll talk about here shortly, is the data subject access request. Today, we can go in the US, we can go into a healthcare organization and or online and request our medical records. That's also going to provide you disclosures of that information. Who have they shared that information with? And thinking out of that scenario, when you walk in, you're going to receive two documents. You're going to receive a privacy notice or notice of privacy practices, and then sharing of that information. And most people say, yes, yes, sign off and hand it over. Now, where that comes into play is who have you authorized that information to be shared with? Generally, the discussion is going to be about with other practitioners to help and monitor your healthcare. Yes, that's great. However, there are new instances where that information is going to be shared with third parties that are not necessarily in that capacity of providing you healthcare, where that's where the concern of that information goes. Now, within that, within the RFI, it's helping to streamline HIPAA. So there's HIPAA 2.0, if you will, that's potentially coming out. Or within that change is also a unified federal privacy act, which potentially would either repel and or replace HIPAA. There are a number of conversations happening on the Hill today regarding that across the US. And if and when that comes into play, that's of course everybody's guess. I don't believe it will happen this next year either, based on with what happened this past year. But with that information of, again, you as an individual, us as individuals, that information of protection of our information is critical. And it has gained immense traction, especially since GDPR came into play. Additionally, we've had CCPA come into play, the California Consumer Privacy Act. Now, that doesn't necessarily take into consideration or doesn't apply to healthcare organizations. However, there are some instances where it does. So there is a case. So let me back up one track. So my role within Lockton is to help our clients identify their exposures, risks, and so forth regarding privacy, data security, cybersecurity. With that also is in data subject access requests, where that information goes. Who is it shared with? Now, the term is sell of information. Healthcare organizations have shared, not sold, shared information with third parties who utilize it for other reasons. The healthcare organization, the covered entity, may receive a reduced rate on something. They may receive something in return. So in California, the actual definition of sell is not necessarily monetary, but it's receiving something in return for that information that's being captured by you as the covered entity or the covered entity. So if the organizations, the healthcare organizations, are sharing information with a spiff, if you will, behind the scene and a reduced rate of some sort, they're selling information. If that is the case, they have to notify you as an individual. They have to also report to the state attorney general that that's a practice that they do. Now, there are other controls that need to be put in place with that. But again, receiving your consent that they can do that. So that is a challenge that's going to come into play starting in July when CCPA starts the enforcement process. Healthcare organizations have been alerted to this. And if they have not changed their contractual obligations, requirements, that potentially be one key area that will be reviewed immediately. That's one of the key factors we have seen thus far. That potentially will be a research area, investigation, if you will. Now, quickly, the California Consumer Privacy Act piece, again, just came into effect this January 1st. And consumers, the big thing about this piece was regarding the opting out of that information. Again, so if you're telling me you're going to take my information and do something, I want to opt out from that capacity, either personally and or online. There is a private right of action. It's minimal to the fact of what the capacity could be, but for a healthcare organization, all it takes is one investigation to identify other individuals within that private right of action can become a class action lawsuit. And that, the reputational damage to that, potentially business interruption to that, of handling that case, anybody who's involved with that as well. So that's going to be interesting to see here in the next couple of months of when and what happens with the first, I'll say, victims of becoming non-compliant with CCPA. Now, the California Confidentiality Medical Information Act has been out for a while. And it also provides additional protection regarding your medical information and what can be done with it. Again, it goes to the fact that you're protecting of the confidentiality, the integrity, and the availability of information. This also goes on how you're handling information. So if you have departments like ER, you walk in and information is compromised, potentially. Individuals' information that's been gathered, the chain of custody of that particular record, if it's sensitive information, if it has genetic information, blood tests and such as that, How is it being transferred to wherever it goes, a laboratory to another laboratory, and so forth? The chain of custody of protection of that information needs to be identified, documented, and processed so that if and when something is lost, compromised, there is a audit trail where that information can be determined of were the appropriate controls in place, were the policies and procedures followed, adhered to. If and when there's non-compliance to that capacity, that again potential has fines that can be levied against either the state attorney general, and or if the OCR does get involved, the Office of Civil Rights gets involved, we may have a breach that needs to be notified. Now we're on the hall of shame of HHS's website, which we don't want to be. And again, just the process of protecting that information is critical for your success of being compliant, but also providing the best care for us as individuals and your patients. Now, the Nevada Senate bill came into play in October 2019. And why I put this up here is because if you're gathering information from any resident of Nevada via online, which all it takes is a name and an email address, you must be compliant to their requirements. That is, of course, protecting, again, the confidentiality, information, the integrity and availability of that information. But also, if you're sharing that information, what are you doing about notifying the consumer of that, receiving their consent to share that information, and how are you protecting it, and so forth. So if you think about, again, walking into the door into a healthcare organization, you become a client, great, or a patient, and then you go home. And now I want to sign on and see if I can access my records on a portal or so forth. And I create an account. You receive my name and you receive my email address. That component right there is your requirement to be compliant to that bill. I understand HIPAA is preempting statutory laws. However, this component hasn't been tested yet, but there's still a concern that this may still apply to your covered entities as well, because you are gathering that information and so forth. And thus far, and I'm going to scroll to the next page here, who's affected? Anybody who owns and operates an internet website or online service for commercial purposes. Collects and maintains covered information from consumers who reside in Nevada and or use to visit the internet website or online service, and purposefully directs its activities towards Nevada, consummates some transaction with Nevada or a resident thereof, purposely avails itself of the privilege of conducting activities in Nevada, and otherwise engages in activity that constitutes sufficient nexus with the state to satisfy the requirements of the United States Constitution. There are no outliners regarding who exemptions, if you will, for who would not be covered by this. So pending further traction, again, and this has only been in place for about 6-7 months. We'll see with what happens, but right now, just take that into consideration. What information you're gathering, how are you gathering it, who are you potentially sharing or selling that information to, is going to be critical, not just for these, but for all additional states that are going to start following these as their models in protecting that information. Now, where that comes into play, additionally, thinking about your hiring process and what you're doing to acquire new talent. Your website or a third party's website that's advertising your job description, somebody is then seeing it, they start clicking and applying for it. You're gathering information, potentially sensitive information on that individual. You're going to gather a name, phone number, email address. You're going to gather their resume, their historical data, potentially references and their information. Now you've implicated additional individuals on this online platform, phone number, email address, so forth. And you go through the hiring process. You might also have a drug screening process where you're having a urine sample and or blood taken, drug tests, and so forth. How is that information being protected? How are those samples being protected? Most organizations that we have seen say, oh, we're not worried about that because it's a third party that we've done it. It's still ultimately your responsibility as the organization that has partnered with that third party to execute that on your behalf, to protect that information, especially if it's online and if the analysis of that information is being shared with a third party or courier or so forth, to analyze the data and so forth. So if I'm an individual and I am applying for a role at your organization, and I'm a resident of Nevada today and potentially in the future other states, and I get through the process and you offer me a position pending my drug screen, if you perform that test, my information is then gathered, my DNA is gathered. How is that protected? I'm going to come back potentially. I'm going to come back and request who has had access to all of my information to include in the hiring process. You as an organization have to show who had the access to that information, how it was protected potentially. And again, ultimately, you as the organization that is hiring me as a healthcare organization and or any organization must show that that information has been protected, has not been compromised, and potentially destroyed once it was no longer required, and so forth. So again, the burden of the proof, if you will, is on the organization to show that they did not compromise and that they were compliant, including the processors of that information, of their third-party information that's gathering it on their behalf. That then leads us to GDPR and where that comes into play and with what it's done to us in the United States. From my view, it's been a good eye-opener for organizations to think about how they handle information, what they do with the information, who they share it with, and now in utilizing the terms from GDPR from a controller or a processor. The controller or the covered entity, if you will, is overall responsible for all protection of that information, no matter where it goes in the supply chain, third-party vendors, and so forth. Critical processes being conducted by a processor or a third party. But again, thinking about that hiring process, the genetic data, the health data itself, where and what is that information being captured for? There are cases, there are claims that are available online to see that third parties, both in the United States and internationally, especially under GDPR in the past year and a half, have been doing drug screening, gathered that information, and then they shared that with a research lab to start doing additional processing of your genetic information because you were going through a hiring process. I would venture to bet you probably didn't know that, didn't receive notification about that, probably didn't provide consent to that or unambiguous consent for that. And that information then has been captured unlawfully and it's being processed unlawfully without your consent and so forth. But there are claims in the works right now that are still going through litigation to determine what happened, how did it happen, why did it happen, and how do we resolve this from not happening further. So that kind of goes back to the California confidentiality of medical information as well, and to the Nevada Senate Bill 220. You as a covered entity, again, globally, does not matter, need to understand where your information is being collected, where is it going, what that processing is being done, be it either internally and or externally. No matter if you've outsourced it, you're still overall responsible for it. And protecting of that information and or depicting what the processor can do with that information and what they are not allowed to do. You depict that. And if you're not depicting that, potentially then your processors become the controllers themselves. And then they need to engage with your client, your patient, on obtaining that consent to do extra work, extra processing of that information and so forth. Now where the OCR has come into play and with what they're trying to do with their RFI, the request for information, starting back, as I said, in December 2018 to streamline HIPAA and or extend it. I provided this for your review just to compare head to head, if you will, with what HIPAA has and with what GDPR does or provides for us as an individual, protection of that information. Within HIPAA, basically basically. Everything is similar to how GDPR lays out, excluding that we in the United States cannot delete that information. You can after it becomes inactive, of course, and after your retention period has expired. Outside of that, we don't have a you need to delete my information requirement under HIPAA. GDPR does provide that. However, there are exclusions to that. Whereas if it is needed, required, if you have a business reason, a legal reason, and so forth, other principal purposes of keeping that information, you do not have to comply with a delete request by an individual. But again, that's where I would definitely focus and consult with your data protection officer, your data protection authority as well, general counsel or outside counsel as well, to make sure that you're doing the right things with those. Now with the adapted proposed extended HIPAA piece, that would provide those types of additional privileges to us as an individual, that we would be able to request the deletion of our information, again, if it's not required legally and or if you have a business purpose for keeping that information for a set period of time. We have a similar, I'll say, a potential claim, not we Lockton, but aware of a claim that has come into play where a healthcare organization, covered entity, US, has a third party that is a minority owner of the organization that is domiciled in the EU, and that information is being shared back and forth what's the right word? Intercontinental, and then overseas as well. So the contractual obligations of sharing that information, understanding how you're protecting that information, the sensitivity of the information, medical information, of the information, of where the individuals are residents of. So forth. The best piece of this is that the patients are within the United States. They are US citizens that are sharing information with consent back, knowing that that information is going internationally. The US organization is not on the Privacy Shield. It does not have a binding corporate rule in its agreement with this organization. So there's some sticky components with that of how they're sharing information back and forth once it goes to Europe, and what the processing is of that information and so forth. But again, just you as an organization understanding the regulatory requirements of protection of data as you transmit it internationally, intercontinental, interstates wise, you need to be compliant in understanding where that information goes, who's using it, and even though you're a covered entity and HIPAA applies to you, if a third party is not complying with that, I understand you have business associate agreements and so forth, but if the third party is still not being compliant to that, you as the overarching covered entity that provided that information is overall responsible for the protection of that information. Even if that third party goes rogue on you, you potentially can be held liable. Now, a few recommendations for you. Basically, apply the existing security rule, the security rules both from HIPAA and GDPR, and there's 126 healthcare acts globally implemented, and they all read differently. They all have different requirements and so forth. But within that, if you can apply your security rule to all custodians and processors, to who has access to your information, and that they're providing the protection required to comply with what you're required to be compliant to, you're going to be doing the right thing. Putting in those in your contracts, doing audits, double checking, third-party risk management, making sure that they aren't sharing information. You tell them that they cannot share information and or sell information outside of your control and so forth, or that you're involved with any subcontractors and so forth. Just taking control of that information. Requiring your custodians processor to directly notify individuals if you so desire. If that is in your process, By all means, there are certain organizations do not like to have somebody representing them or to their patients that their information has been compromised, and they may take precedence, but that goes back to your incident response plan and ensuring compliance with that and following breach notification laws, both within the US and internationally. And then establishing, this is a long-winded statement here, but establish specific consumer-friendly granular notification requirements. Every state has their own notification. Every territory has their own notification. Every regulatory mandate has its own notification process. Being transparent, sharing that information with the individuals who are potentially impacted, being proactive about it, helping them understand what the exposure was, what can they do to protect themselves. If their social security numbers weren't impacted, credit monitoring probably isn't required, but what else can you do to help themselves and be a partner with them in this process? The worst thing is that we've seen from a claims handling process is that a healthcare organization notifies that you've had an incident, they follow the requirements, but that's it. There's nothing more to it. They're not necessarily helping the impacted individuals. Go that extra little bit of mile and you will retain some of your patients' trust. They'll feel as you're taking care of them versus they had to notify me, they did, and that's it. Help themselves. I think that's just with what I've seen in the past few years with claims from healthcare organizations that have had losses and compromise in protecting the access of information. I mean, that's the biggest thing. But yeah, so then global privacy laws are increasingly going to put consumers in control of your data, how you protect it, what they need from you, who has it, what are they doing with it, when did they get it, why do they have it, did I give you my consent on that, when did I sign that form, and so forth, and being able to respond in a timely fashion for that, and then be able to just protect that information, not just electronically, but physical papers still are in play globally, not just in the US, but physical paper trails are still being utilized, especially handwritten notes that are potentially scanned into an electronic medical record, and that note goes into a file that's still a part of that individual's file, and now it becomes a part of the record because it's in the file, and it's still handwritten. So protection of that confidentiality of that is critical. The availability of that information to validate that that information was accurately scanned, that nothing was altered from the original document to a secondary document. The chain of custody is a big piece of that pie. So if you can accomplish that, put in your framework appropriately to identify where information comes in and apply a classification policy to that information, apply the appropriate controls to that, you're doing the right thing. Monitor your third parties, ensure that they do the right thing as well, and you will be seen as you've done your due care. Just continue to do your due diligence on protection of that information, and you should be pretty good. With that, that's all I have. Any questions from the group?